And I'm gonna send Hurley down.
All right, Ben, are we back on record on this case?
Yes, we are.
All right. Look, regret to reflect that Ms. Hapner has now joined us after some technical challenges.
Thank you for your patience, Your Honor.
Not a problem. Case number 20 CR 11 and 20 CR 98, State of Ohio versus Anita Withrow. This hearing being conducted by Zoom, and Ms. Hapner, you and your client both agreeing to conduct this hearing by Zoom and waive any in-court personal appearance.
Yes, Your Honor.
Do you agree with that, Ms. Withrow?
Yes, sir.
Okay. All right. Now we have case number 20 CR 11. Defendant is charged with aggravated possession of methamphetamine, and in 20 CR 98, he's charged with failure to appear. Now, I've been presented with some plea agreements in each case. I'm going to have to change my background because when I use a virtual background, it doesn't like to show my documents I need to hold up to you. So, excuse me, I don't want to do that. All right. Okay. So, 20 CR 11, there's an agreement I have that's Withrow, which I'll hold up to the camera. And you see that says your name and case number?
Yes.
It says plead guilty.
Yes, sir.
All right, and on page 3, there's a signature line. Right below a sentence that reads, I enter this plea voluntarily. And I'll hold that up to the screen, and right there next to my index finger, you see that?
Yes.
Is that your signature?
Yes, sir.
All right. Now, in case number 20 CR 98, I'll also hold that up, and then you recognize that agreement there.
Yes, sir.
And on page 3, again, there's a signature line that right above which says I enter this plea voluntarily. And is that your signature there that you're looking at on the screen?
Yes, sir.
All right. Now, when did you sign these agreements, Ms. Withrow?
It was one day last week, Your Honor.
Yeah, it's been
All
effective.
right. And Ms. Hapner was with you when you signed them?
Yes, sir.
Did she go over them with you and explain them to you to answer any questions you had?
Yes, sir, she did.
And did you understand that each of these documents are agreements to plead guilty, which means there won't be a trial. The next step in your case would be a sentencing hearing.
Yes, sir.
Did you have enough time to fully consider this matter before making this decision?
Yes.
And is this still what you want to do now, today on the 1st of December?
Yes, sir.
Are you entering into the agreement, or did you enter into the agreement, and are you agreeing to plead guilty voluntarily?
Yes, sir.
Right now, on the first case, 20 CR 11, it says you're going to withdraw your not guilty plea, plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the revised code, a fifth degree felony. That you understand that the maximum penalty for that could be 12 months in prison. The minimum is 6 if the prison term is imposed. There could be a fine of $2,500, and there could be a license suspension of 6 months a year.
Yes, sir.
20 CR 98, the fourth degree felony, failure to appear under 2937.99, and it states that you understand that the maximum penalty for that could be 18 months in prison. The minimum would be 6 if the prison term is imposed, could be 6, and there could be a fine of $5,000. You understand that?
Yes, sir.
Now, if you are convicted of both of these charges, and if you are sentenced to prison, the court could order those sentences to be run consecutively, meaning one after the other. So that means that the total maximum penalty for this could be 30 months in prison and $7,500 fine, and a license suspension in the methamphetamine case, possession case of 6 months to 5 years. You understand that?
Yes, sir.
Other than these charges, are you facing any felony charges in any other jurisdiction?
Yes, sir.
Are you currently under community control, post-release control, probation, or parole from any jurisdiction?
Yes, sir.
All right, now, under the law, if you are convicted of these offenses and if you are sentenced to prison, upon completion of that prison term, it is possible that the adult parole authority could decide at their option to place you under what's called post-release control supervision for a period of up to 2 years. They don't have to, they can, but they make that decision on the court. And if they decide to do that, you'll be supervised by a parole officer on the term set by the parole authority. And if during that period of time that you're being supervised, they determine that you have failed to comply, then they could return you to prison to make you serve an additional period of up to 9 months for one violation, although there would be a limit or a cap of 6 months, of 1/2 of your prison term for one or more violations. However, if your violation is a new felony, then in addition, or not your violation, but if you commit a new offense while under post-release control supervision, then in addition, whatever sentence a judge in that new case could impose upon you, that judge could also sentence you in this case to an additional period of 1 year, or whatever time that on the 3 years of post-release, or the 2 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the case. You understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for either of these offenses. I can impose a sentence of community control, which means that instead of going to prison, you would be put under supervision of a probation officer on a term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court, serve a copy on you. You would be you would have a hearing. You would be entitled to have an attorney, and if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to a total of 30 months in prison and fine you $7,500 on the 2 charges. You understand that?
Yes, sir.
In the case, the charge of 20 CR 11 alleges that on or about October 6, 2019, in Highland County, Ohio, you did knowingly obtain, possess, use a Schedule II controlled substance with methamphetamine, which would be a violation of 2925.11 of the Ohio Revised Code, aggravated possession of methamphetamine, the 5th-degree felony. Case number 20 CR 98 alleges that on or about February 9, 2020, in this 19, I should say, 2020, in this county, you did recklessly fail to appear as required in Highland County Common Pleas Court case number 20 CR 11 after having been released pursuant to ORC 2937.29, and the release was in connection with the charge of commission of a felony, violation of 2937.99. So that's the failure to appear charge. Now, Ms. Withrow, do you understand what you've been charged with in each of those cases, what the state said you did, when, where, and how they allege that you did it?
Yes, sir.
Have you discussed the nature of each of those charges, the possible evidence in the case, the possible legal issues in the case, possible defenses you could try to raise in each case, and possible outcomes of a trial in each case with your attorney?
Yes.
Are you satisfied with your advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs there at the jail?
No, sir.
Have any threats been made to get you to plead guilty to these charges?
No, sir.
Right now, on each of these documents, about 3/4 of the way down the page, there's 2 sentences printed in bold and underlined, and I'll read those as follows. They're the same in each document. Finish on or plead guilty to the indictment, state defense, jointly recommend community control, and substance abuse treatment. That's your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the court's not required to follow the recommendation of sentencing of the parties. And so, even though the state's in agreement that you should get control or probation instead of going to prison, I'm not bound by that recommendation. And so, once I receive all the information submitted, if I decide that's not the correct sentence, I could impose a prison term of up to 30 months and a fine of up to $7,500 and suspend your license for 6 months to 5 years total for both charges. Do you understand that?
Yes, sir.
Do you hold any license or certification from any state board that governs any occupation or profession?
No, sir.
All right, now, you have certain rights you must understand before I can accept the plea of guilty from you in these cases. First, you have a right to have counsel. Ms. Havner was appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you wish her to provide. So, if you decide that you don't want to plead guilty in either or both of these cases, she'll continue to represent you and defend you, including having a trial if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in each of these cases, in which 12 people would be selected to serve on your jury from a group of citizens that are summoned for jury duty that live in this county. Once those jurors were selected, the evidence would be presented, they'd be instructed on the law at the conclusion of the evidence. And then in each case, the jury would have to decide by unanimous verdict, meaning all 12 would have to agree, as to whether or not the state proves your guilt, proved beyond reasonable doubt of either or both charges. Now, if you did not want to have a jury trial in either or both cases, but you didn't want to plead guilty, then you can waive or give up in writing your right to have a jury trial. Waive, that means waive, is what that means, or get out. I mean, waive is a legal term, give up is what it means. And then in that case, you would have a trial to the court, which means the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt instead of a jury. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you in each case in open court and to have them cross-examined by your attorney. What that means is that the witnesses against you in each case would have to come into court and testify in front of you, the jury, and anyone else who would be present at the time. Once the prosecutor's done asking questions, your attorney can ask questions, which is called cross-examination. And the purpose of that would be to try to bring out evidence that will help your side of the case in either or both cases. You understand that?
Yes, sir.
Right now, in each of these cases, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses that you're not certain are going to come in voluntarily at your request, the court will issue a subpoena, that's a court order, and that forces those people that you want to come to court to be here to testify on your behalf, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination in each of these cases. What that means is that you cannot be forced to give evidence against yourself at any time, including trial. So no one can ever make you testify. Prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by anyone at any time in either case. And in fact, no one will be allowed to talk about it in either case except in one situation. If there's a jury trial in either or both cases, excuse me, and you do not testify, then the judge will instruct that jury that because that's your constitutional right, they cannot consider that for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent in each of these cases until proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you are. So at trial, you're not even required to present any evidence in your defense. You may, but you're not required to, whether you do or not. The burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense in the case, in each of the cases, which is the, and it has to be done by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea not guilty to these charges. That plea denied the allegations in the indictment. In each case, denied you committed the crime and exercised or invoked all the rights that I've just described. You change your plea from not guilty to guilty. That is the opposite of the not guilty plea. The plea of guilty, in each case, would admit the allegations in the indictment are true and that you committed them and that that's a crime in each case. And that plea, in each of these cases, would waive or give up all the rights that I've described today, except one, your right to have counsel. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to have a jury or court trial. Waive or give up your right to confront witnesses against you and to cross-examine them for your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, same as the state. Would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you're guilty. And it would waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. Now, the plea of guilty also subjects you to being sentenced immediately by the court, if that's what the court feels is appropriate. And finally, it would waive or give up your right to file an appeal if, as of what's happened in each case as of today. Now, if you are sentenced to the maximum sentence or under the certain circumstances that are limited, you could file an appeal. That would have to be filed within 30 days of your sentencing after being filed in that particular case. Now, and each of those things apply to both cases.
Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Yes.
Right, now, do you have any questions about the charge in either case or the possible penalties for each charge?
No.
You understand?
Yes.
You have any questions about the plea agreements?
No.
You understand them?
Mm-hmm.
You have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, and what the consequences of that will be?
No, sir.
You understand that?
Yes.
Now, since you're not sitting next to Ms. Hattner in the courtroom, if you need to talk with her, I can put you and her into a breakout room where the two of you can talk, and no one else will be able to see you or hear you. Do you need to say or speak with her about anything or ask her any questions?
No.
You have any questions at all about what I've gone over with you here today?
No, no, sir.
All right, then is it your decision, Ms. Withrow, to go forward with these plea agreements that you executed last week and her pleas of guilty in each of the charges, in each of the cases?
Yes.
All right, and as to case number 20 CR 11, which alleges that on or about October 6, 2019 in Huntington County, Ohio, he did knowingly obtain, possess, or use a Schedule II controlled substance to methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, fifth-degree felony, carrying a possible prison term between 6 and 12 months, fined up to $2,500, and possible license suspension 6 months to 5 years. How do you plead?
Okay.
And in case number 20 CR 98, that alleges that on or about February 19, 2020, in Highland County, Ohio, he did recklessly fail to appear as required in Highland County Common Pleas Court case number 20 CR 0011 after having been released pursuant to ORC 2937.29. And the release was in connection with the charge of commission of felony, violation of Section 2937.99 of the Ohio Revised Code, charge of failure to appear, a fourth-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000. How do you plead?
Guilty.
All right, the court finds that this day in open court, defendant was advised of all her constitutional rights in each of these cases, made a knowing and intelligent voluntary waiver of same on February 11th. Pleas are accepted in order filed in each case. Defendant is found guilty in case number 20 CR 11 of aggravated possession of methamphetamine as charged therein, and in case number 20 CR 11 of failure to appear as charged therein. The court will order that a pre-sentence investigation be conducted, and Officer Fulton there, you see on the screen, he's the PSI officer of the probation department, so he'll be in touch with you. That report will include an assessment for substance use disorder treatment and or mental health treatment. And sentencing will be set for January the 5th at 9 a.m. Bond will be continued. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, who else do you have, Ms. Hattner?
Stephanie Fleming.
All right. You bring in Stephanie Fleming then, officer?
She's not in jail, Judge.
I just think she was in custody.
That's right, never mind. Okay, never mind. Well, we'll have to wait a couple minutes then.
Yeah.
And then we'll call her case. See if you can get in touch with her, Ms. Hattner.
Okay.
All right, let's see, who are you there at the jail?
Mr. Bender?
All right, Jeremy Bender.
Sir.
I think that Armin Trout is your attorney, and looks like we've lost him. Ben, would you send a text, Mr. Armin Trout, tell him to log back in? Mr. Armin Trout's your attorney, right?
I think it was Vinny. I'm not sure.
Oh, yeah,
And
sorry.
Mr. Kirk.
It is Kirk, that's right. Okay. He has Joshua Moore, Bill does. Okay. All right, well, Mr. Kirk is still running behind, so
Would you like me to step over to the next group?
yeah, well, just wait right there and let's see who else we might have to do while we're waiting to see Mr. Kirk.
we did Mr. Hurley. Mr. Moore not till 2:15 though. All right.
Denny's logging in now, Judge.
He's what?
Logging in now.
Oh, okay. All right, good. There he is. Hey, Ben, we'll go ahead and go on record on Mr. Bender.
Yes, sir.
Okay, this is case number 20 CR 81, State of Ohio versus Jeremy P. Bender. You're Jeremy P. Bender appearing from jail.
Yes, sir.
All right, this hearing is being conducted by Zoom. Mr. Bender's attorney is Dennis Kirk. He's appearing from his office. And Prosecutor Collins is appearing on behalf of the state from her office. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial. Final pretrial set for the 15th of December, and trial date set for January the 11th.
He has 2 cases, Judge.
Yeah, I see that here. In case number 20 CR. Well, hold on for a minute. There it is. 21 CR 167. Mr. Bender is charged with failure to appear. And I believe we have the same trial schedule. All right. Now, see that bill particulars were provided in the 167th case. And I believe discoveries complete have been provided by the state in both cases. Is that correct?
That's correct, Your Honor. I've received discovery in both cases.
All right. And have you filed yours yet?
I have not yet.
All right. Well, it'll be due by final pretrial. Do you anticipate any pretrial motions?
Not at this time.
Has there been a written plea offer provided?
Yes, Your Honor.
Okay. Is your client aware of that, Mr. Kirk?
He is, Your Honor.
All right. All right. Are there any other matters then that need to be discussed at this time?
But just raise the matter of bond again. I know he's been on the failure to appear, so obviously not going to insult the court by asking for an OR bond, but we'll just ask the court to review the bond and perhaps it could be lowered. He's unable to make the current bond.
Well, given the history of failure to appear that will be denied, I think that's a reasonable bond to ensure his appearance. All right. Anything further then on this case?
No, Your Honor.
All right. Thank you.
Mr. Kirk? Mr. Kirk,
Yes.
have you had a chance to speak with your detective?
I will come out to the jail and talk to you.
Record then on Deputy Planning. All right, case number 21 CR 162. Oh, are we on record then?
Yes, sir.
Okay, 21 CR 162, State of Ohio versus Stephanie Fleming. This hearing is being conducted by Zoom. Fleming's attorney is Catherine Hatner. She is present from her office by Zoom. Prosecuting attorney Collins is present from her office. The defendant is not present. I did see that there was a motion filed by the state to revoke the defendant's bond. And also I had a notice from the probation department that she was, her main motion from the state to
vote for bond, and then, fax release, probation department indicating that she was, non-compliant. Ms. Hapner, were you able to get in touch with your client?
I did. I spoke with her just a few minutes ago while you were doing Mr. Kurt's hearing. She asked me to ask for a continuance of this hearing. I informed her that the state had filed a motion to revoke her bond, and that I did not think it was likely that you would grant a continuance, but that I would ask.
All right.
She indicated that she was trying to log on but was having trouble doing so.
Well, according to the probation department fax dated the 29th, she's tested positive on the 5th November for meth. Or no, that was an admission, and then on the 12th she admitted she was positive for meth, amphetamines, and fentanyl, and she's not reported back since the 12th. She was referred to FRS, but they been no evidence provided that she has done that. And I see no evidence of her trying to log on. And given her history, at least what's been, I think that the court will, of course, deny the motion to continue. We'll order a case to issue for her arrest. And then once in custody, then we'll review the matter to see what her situation is. But I think that there's some concern about her physical health as well as her appearance before the court. So, court will order a case to issue.
Matter is the trial for the 16th off.
Yeah, I will vacate. Yeah, the trial date will be vacated. Thank you for bringing that up. I didn't even look at that. Because there would be no way that this happened to be able to be prepared by that day. And we don't know if she'll be here by then, so that'll be, we'll vacate that.
Thank you, Your Honor.
All right. Anything further on this case?
No, Your Honor.
Okay. All right. Thank you.
Thank you.
So I think that the next case P1CR150, State of Ohio versus Jason R. Carnine. This hearing is being conducted by Zoom. It's a pre-trial. You are Jason Carnine there with your attorney, Laurie Tacoli. Yes. All right, and the prosecuting attorney, Collins, is appearing on behalf of the state from her office. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is the final pre-trial. The trial is set for December 16th. All right, now, is discovery complete in this case?
It is from the state. We've disclosed all of our witnesses and done additional discovery. I have asked Rachel Hine to provide me with a written statement. If she does so, I will forward that as additional discovery as well.
All right. Has the defense provided their discovery?
I don't believe we have any to provide.
They have not.
You have to, okay, you have to file something. If you have nothing, you have to file that statement. You have nothing. All right, so that's supposed to be done by today, so I'll give you till Friday to do that.
I'll do it today, Judge.
All right. Now, other than your motion to continue, there are no other pretrial motions, right?
Right.
Okay. All right. Now, the question here, or the motion is a request for continuance for plea negotiations, and I'm a little at a loss of what needs to be, whether it needs to be continuance. It's a 5th-degree felony. Can you give me some illumination on that, Mr. Colby?
I can, Your Honor. There has been, I guess, it was offered potentially a stipulated polygraph. Mr. Carnine has been contemplating that, and we may ask the prosecutor to allow us to set something up in that regard. We do think we toward a plea sometimes, and not a trial. We were just asking for additional time. They set it out for another final pre-trial, anticipating that we will be able to resolve.
All right, so he's going to take a polygraph, or he's not?
But that, I believe we are probably going to move forward with that, and I'm going to get in touch with Collins to see about setting that.
All right.
I apologize. I'm unfamiliar. I don't do that typically here in Claremont, so I wasn't not entirely sure of the process, but I'll get in touch with her.
All right. Well, the prosecutor usually sets that up. How quickly do you get that set up, Mrs. Collins?
Usually they can get them finished within about 2 weeks.
Okay.
It depends on if they have everybody in with a holiday and things.
Yeah, we had requested just 30 just because of the holiday and the delay there.
Is something you need to tell us about? Okay. All right.
Mr. Carnage's families have some health issues.
Okay. All right. What we'll do is we'll continue the pre-trial then to January the 5th at 2:15. That can be by Zoom. Trial will be continued until January 27th at 8 a.m. And time is waived.
Yes, Your Honor. He's under time waiver on the week.
Okay. All right. So, Mr. Carnine, then keep in touch with the attorney about the scheduling of the polygraph. And there will need to be a written agreement to that presented to the court. And we'll go from there. All right. Anything further from counsel then?
No.
All right. Thank you. All right. Mr. Moore is there, I think. Yeah.
All right, so we'll go Joshua Moore, Ben.
Yes, sir.
All right, case number 21-CR-144, State of Ohio versus Joshua L. Moore. You are Joshua L. Moore, appearing on the screen, mark Joshua Moore. You need to unmute yourself there, Mr. Moore, you're muted. You need to click on the unmute button. There's a button there at the bottom of your screen. You may have to scroll down. It says, looks like a little microphone. There you go.
There we go. I'm sorry.
All right, you're Joshua Moore.
Yes, sir.
This case 21-CR-144, State of Ohio versus Joshua L. Moore. Mr. Moore's appearing by Zoom. Mr. Armentrout, his attorney, is appearing by Zoom, and appearing on behalf of the state is Prosecutor Collins, also by Zoom from her office. The defendant's charged with breaking and entering and theft. This is a final free trial, and I believe we have a trial date set in January.
December 16th.
Oh, it's December 16th, all right. Okay. Is the discovery complete then?
This from the state.
Armentrout?
Thank you, Your Honor. I'm sure that I complied with it. I believe we have a resolution to the matter here. I just need to get Mr. Moore in here to go over the plea. I don't see where I can comply with discovery, Judge. I'll do that immediately. And I don't
This case is set for trial on the 16th, so 15 days will be up tomorrow. Mr. Moore, you get your attorney's office tomorrow to sign this?
Yes, sir.
All right.
Josh, what is your phone number?
Hold on, I'll pass through it. Danielle. Hey, what's the phone number? 937-515-6249.
Josh, as soon as we've completed this hearing and you log out, I'm going to call you, okay?
Okay.
All right, we need to get a hearing set up for that plea, Mr. Armentrout. Do you have time tomorrow?
Tomorrow between like 11 and 1 would be good, Judge, if you got any time in there.
Well, I was supposed to go to a judge's meeting, but I'm not going to go because of my wife's situation, so we'll do it at 11 a.m. So, Mr. Or you need to get, well, what time you want him there at your office, Mr. Armentrout? You want him there at 11 to do this at 11:30?
Yeah, that'd be better, Judge, yeah.
All right, so we'll get the hearing set for 11:30. So, Ben, tell Mrs. Boyer to send out an invite to parties and to me so we can do this tomorrow
Yes, sir.
at 11:30. Okay, and then, so you need to be at your attorney's office at 11, Mr. Moore. And before that, you need to go to the probation department because I've got another report from you that you haven't reported since the 22nd. And you're supposed to on the 24th and you didn't. So you need to get in and see them so that, you don't make this situation worse than it already is.
Yeah, yes, sir. I
don't need an explanation the old, what my dad used to tell me is the best thing you can say is no excuse, sir, and move on, okay? As when you're dealing with the court, unless you're in the hospital or dead, there's no reason for you not to be doing what you're supposed to be doing. All right. So tomorrow, we'll see you tomorrow. You go to your attorney, go to the probation department tomorrow. Mr. Arzima right down there in the corner. You can see him. And then you go to your attorney's office at 11 so we can do this hearing at 11:30.
Okay.
Josh, I'm not going to call you now. You just be here at 11.
Okay.
All right, you can log off, Mr. Moore.
All right, thank you.
All right. All right. Now, let's see. Can I have someone there on that needs to unmute the yellow shirt, sir? If you can unmute your mic. And what is your name, sir? Okay. Are you Mr. Riley's attorney, Mr. Armstrong?
Yes, sir.
I thought you were. All right. Hey, Ben, we'll do case number 21-CR-175, Michael Riley.
Yes, sir.
Ready?
Yes.
Okay. Case number 21-0175, State of Ohio versus Michael Shane Riley. Mr. Riley is appearing by Zoom on a screen that has the phone number there, it looks like, and numbers, a series of numbers, 893-416-56988. That may be not a phone number. I guess that's an IP number. You are Michael Shane Riley, correct? Yes, sir. Right. Mr. Riley's attorney is William Armentrout. He's appearing by Zoom, his office. And the prosecuting attorney, Mrs. Collins, is appearing from her office. Defendant charged with receiving stolen property, a fourth-degree felony. This is a first pretrial, final pretrial set for January 5th, and trial is set for January 24th. I see the state has provided discovery, and Armentrout, have you provided your discovery yet?
No, Your Honor.
All right. Well, it'll be due by final pretrial. Do you anticipate any pretrial motions?
None.
And has there been a written plea offer provided?
There has, my client's been made aware of it. He's contacted my office to get an appointment in the next day or two to see how we're gonna proceed with this.
All right. Okay, is there anything else then to discuss?
No, sir.
All right, then keep in touch with your attorney there, Mr. Riley, and we'll see you at your next pretrial. Okay, thank you. All right, let's see. And Kevin Williams, that's Ms. Witt's attorney, or inclined to believe. Okay, are you Kevin Williams on Brittany's Galaxy A20?
Yes, sir.
Okay, this is case number 21 CR 155, State of Ohio versus Kevin Eugene Williams, Jr. Appearing on behalf of the defendant is attorney Danielle Witt. Appearing on behalf of the state is prosecuting attorney Collins. The defendant is charged with receiving stolen property, fifth-degree felony. Let's see here. This is a final pretrial, I believe. Trial is actually set for the 13th of December. All right, where do we stand on this case, counsel?
Mr. Williams signed a plea form earlier today, Your Honor.
Oh, I'm sorry. Yes, you did. I don't remember. Let me go pull that up. It was
Like 10 minutes ago.
yeah, it was sent to me. Let me get it up here.
We brought it over to Marcia and asked her to scan it real fast.
She did. Yeah. And I think I accidentally. Oh no, there it is. All right, good. All right. Great. All right, Mr. Williams, I'm going to share my screen here that will show this plea form. There it is. All right. Now, can you see that plea form there, Mr. Williams?
Yes, sir.
All right. And that indicates your name and case number says you're going to plead guilty to the charge on that page. I'm going to go down to the third page. And right there where my cursor is a sentence that reads, I entered this plea voluntarily. And is that your signature right below that?
Yes, sir.
All right. And when did you sign this form, Mr. Williams?
Just a little while ago.
Okay. And were you at your attorney's office when you signed it?
Yeah.
And did she go over with you and explain it to you before you signed it?
Yes, sir.
And did you understand that it's an agreement to plead guilty, which means there won't be a trial the next after your case will be a sentencing hearing?
Yes, sir.
You feel you had enough time to fully consider this matter before making this decision?
Yes.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Now, the agreement says on page 1 you're going to plead guilty to the charge of receiving stolen property under 2913.51 and provides code 5th-degree felony. And it further states there that, whoops, went a little too far, that you understand that the maximum penalty is 12 months imprisonment. The minimum would be 6 if prison is imposed. There's also a fine of up to $2,500. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Under the law, Mr. Williams, if you should be sentenced to prison for this offense, then when you complete that offense, it is possible that the adult parole authority would exercise the option to put you on what's called post-release control for a period of up to 2 years. What that means is you'll be supervised by a parole officer until the term set by them, because the court has nothing to do with that. And if that happens, and they determine that during the period of time that you're being supervised that you have not complied with those conditions, then they could return you to prison, make you serve an additional period of up to, in this case, half of the prison term for one or more violations. But if you are convicted of another felony while you're in post-release control supervision, then in addition to whatever sentence the judge in the new case could impose upon you, that judge could also sentence you to an additional period of, for committing that offense while under PRC in this case, to an additional term of 1 year, or whatever time would be left on that period of post-release control, which again could be up to 2 years, whichever is greater. And if that occurs, that would have to be served consecutively to the new charge, meaning after that. You understand that?
Yes, sir.
Under the law, Mr. Williams, I'm not required to send you to prison for this offense. I can impose what's called community control. And what that means is that instead of being sent to prison, you can be put under the supervision of a probation officer at a term set by the court for a period of up to 5 years. Now, if during that period of time probation department felt you were not complying, then they could file a written notice of that report, serve a copy on you. You would be entitled to have a hearing, and if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you 12 months and fine you $2,500. You understand that?
Yes, sir.
Right now, the charge in this case alleges, Mr. Williams, that on or about April 7, 2021 in this county, you did receive, retain, or dispose of certain property, being an auto crane 3203, property of another Aaron Baldwin, and that you knew or had reasonable cause to believe had been obtained from commission of theft offense, said property being valued at equal to or greater than $1,000 but less than $7,500 in violation of section 2913.51 of the Ohio Revised Code. So that's the charge for receiving stolen property. Now, you understand what it is you're charged with, what the state said you did, when, where, and how they alleged that you did?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of the trial with your attorney?
Yes.
And are you satisfied with your advice and her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any type of prescription drugs?
No.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, there on page 2, there are 3 lines. It's on the screen, and they're printed in bold and underlined. You see those?
Yeah.
All right, they read as follows. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend committing control. The defendant be referred to drug court. Defendant agrees to make restitution to Aaron Baldwin in the amount of $3,500. Is that your understanding of the agreement?
Yeah, I thought it was community control, but does it say the same thing as drug court in it?
Well, no. Community control, it means you don't go to prison. Drug court is a different type of community control. It's community control, but it's a different program. It's more intensive program designed toward treatment. And you have to apply to be admitted into that, and the court would then have to determine if you're eligible and appropriate for that after you've been assessed.
Oh, so you get, all right.
So you will have to be, if you enter a plea of guilty, I would refer you to the drug court, since that's the recommendation, and then you would be assessed and determine whether or not, after you just talk with a coordinator, you want to apply for admission. I don't order people in the drug court; they have to apply and want to be in the program. So she'll just, they'll discuss that with you, and then I'll make that decision. But that's a different type of community control compared to regular community control.
All right.
Any other questions?
No, sir.
Okay. And by the way, if you want to talk with your attorney about anything while we're having this hearing, I forgot to tell you this at the beginning, just tell me, I'll put you and her into a breakout room where the two of you can talk without anyone else being present or hearing you or seeing you. You understand that?
Yes, sir.
Okay, so just tell me if you need to talk or ask for something. All right. Now, a amount of $3,500 is stipulated to Ms. Witt.
Yes, Your Honor.
All right. Now, Mr. Williams, just so you know, under the law, the court is not bound by the sentencing recommendation. And so even though both parties are saying you should get community control and also be considered for drug court, which again, that's optional and it has to be something you want to do and the court decides you're appropriate for it. But I'm not bound by that recommendation. So if you plead guilty, once I've heard all the information submitted, if I decide that community control is not the correct sentence, I could sentence you to prison for 12 months and fine you $2,500 instead of giving you community control or probation. You understand that?
Yes, sir.
Now, do you hold any kind of license or certificate from any state agency that regulates any type of professions or occupations?
No, sir.
Right, now you have certain constitutional rights you need to understand. Would you mind putting your head down, by the way? This is a court proceeding. Or getting your hand down off your head.
Sorry.
Yeah.
I didn't know what you could see with this thing pulled up.
Well, yeah, I'm looking right at you. There's all right. So, under the law, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel. Ms. Swift was appointed to represent you not for the purpose of working a case out only, but to provide any defense that could be available to you under the law that you wish to provide. So if you decide you don't want to plead guilty, that you want to fight the case, then she'll continue to represent you and defend you, including having a trial if that's what you want. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they'll be instructed on the law by the judge, and then that jury will decide by unanimous verdict, meaning all 12 would have to agree on the verdict as to whether or not the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in legal terms, your right to have a jury trial, and in that case, you would have what's called a court bench trial. That means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law. The judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them for your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions on your behalf. That's called cross-examination, and that is for the purpose of trying to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, the court issues a court order, that's called a subpoena. That forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one can even talk about it except in one situation. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that's your constitutional right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now in the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So, burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to present any evidence in your defense at all at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty to the charge. The not guilty plea denies the allegations in the indictment, denies that you've committed a crime, and that plea exercises or invokes all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is a complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're true, and that you committed the crime that's charged therein. And that plea waives, gives up all the rights that I just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty will waive or give up your right to have a jury or court trial. It'll waive or give up your right to confront the witnesses against you and to cross-examine for your attorney. It'll waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It'll waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It'll waive or give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. And finally, it waives, gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I were to sentence you to the maximum sentence, or under certain circumstances, you could file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Now, and also it does subject you to being sentenced immediately, or if I decided to. Do you understand all those things?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right. Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes.
Do you understand the constitutional rights of each claim?
Yes, sir.
Do you have any questions about those?
No, sir.
Now, do you understand the plea of guilty, what it means, what the consequences of that could be if you enter in here today?
Yes, sir.
Now, is there anything you need to speak to Ms. Wood about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here today?
No.
Then is it your decision, Mr. Williams, to withdraw your ongoing plea? Plead guilty to the charge pursuant to the terms of this written plea agreement?
Yes.
All right, then as to the charge that alleges in the indictment that on or about April 7, 2021, in Highland County, Ohio, you did receive, retain, or dispose of certain property, being an auto crane 3203, property of another, Aaron Baldwin, and that you knew or had reasonable cause to believe had been obtained for commission of theft offense. Said property being valued at equal to or greater than $1,000 or less than $7,500 in violation of section 2913.51 of the Ohio Revised Code, a fifth-degree felony, receiving stolen property carrying possible sentence between 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
And I forget if I asked you, but you are a U.S. citizen, right?
Yes, sir.
Thank you. All right, the court finds on this date open court defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Please accept the file. Defendants found guilty of the charge in the indictment as set forth therein. The court will refer the matter for a pre-sentence report. So you report to the probation department. Contact Mr. Argina there. You have his number.
Yeah, I got his card.
All right. Well, as soon as we get done here, you call him, and then he'll get an appointment set up for you to see Mr.
Sure.
Actually, you let him call Mr. Fulton.
I'm not in the office today. He's got an appointment tomorrow.
Oh, okay, then just take care of it tomorrow then. All right, that's fine. And then Mr. Fulton will be the one doing your PSI. That will include assessment for substance use disorder treatment as well as mental health, and the court will refer the matter to the drug court coordinator for review. Sentencing will be set for January the 5th at 9 a.m. All right, is there anything further from counsel?
Hey, guy.
All right. Then you make sure you keep your appointment tomorrow and, at the office, and they'll set you up with Mr. Fulton there for your pre-sentence interview. All right. I believe that completes the docket. Thank